Okay, today I'm going to talk about student records and the importance of why we as educators need to know about the processes associated with the student records. So the first thing is the definition of student records, and the primary purpose is to maintain educational records, and they should be to aid personnel in developing the best educational program for each student. An effective student record contains information for counseling, program development, individualized instruction, grade placement, college admissions, and a variety of other purposes. Okay, so a student record includes directory information, family background information, health records, progress reports, achievement test results, psychological data, disciplinary records, and other confidential material. There has been a lot of discrepancy about what is actually included in a student record, but these are the most important things, and everything else falls into one of these categories. Okay, so FERPA is the Family Educational Rights and Privacy Act, and this protects the confidentiality of the student records. It may also be known as the Buckley Amendment, and it was enacted by Congress in 1974. FERPA was designed to ensure certain types of personally identifiable information regarding students that won't be released without parental consent. Okay, so how does that play into the schools? FERPA applies to all school districts and any school that receives federal funds. And schools should develop policies and procedures that include the types and locations of educational records, the persons who are responsible for maintaining confidentiality of the records, and the copies of these policies and procedures should be made available to parents and/or students upon request. Okay, so here's a little bit more of clarification about what the educational records include and what they do not include. So they do include records, files, documents, and other materials that may contain information directly related to a student and maintained by an educational agency or institution or person acting for the agency of institution. The educational records do not include instructional records, supervisory records, the records maintained by law enforcement units for law enforcement purposes, or records on 18-year-old students attending a post-secondary institution that are maintained by a physician, psychiatrist, psychologist, or other recognized professional involved in the treatment of the student. Schools must have an annual notification, and within that annual notification it must include the right to inspect and review educational records, the right to seek amendment of records believed to be inaccurate, misleading, or in violation of Students' Privacy Act, the consent to disclose personally identifiable information contained in students' records except where the Act authorizes disclosure without consent. It must include the right to file with the department a complaint under 99.63 and 99.64 concerning alleged failures by the educational agency or institution to comply with requirements of the Act. And it must include procedures for these rights and specifications of criteria for what constitutes a school official and a legitimate educational interest, because there must be a legitimate educational interest by the school personnel to view a record. So there needs to be a procedure for how a parent or student goes to find the right to inspect and review educational records, or a procedure for seeking amendment of the records. It must include an educational institution must notify parents or any disabled student who is eligible about the annual notification. And an educational agency or institution of elementary and secondary education must notify parents who have a home language or primary language other than English in their native language. In addition, students and parents must be informed about the procedures to access their educational records. The rights of parents when it comes to school records. Parents do have the right to inspect their child's records. If they do, there should be a school official appointed to answer any questions and help understand any information that the parents may not understand in their child's student record. Parents may challenge the accuracy of the information in the student record. If a parent chooses to challenge, the school should schedule a conference within a reasonable period of time, usually within 10 days, to discuss that information that may be deemed inaccurate or inappropriate or misleading. If an agreement is reached, then the appropriate deletion or correction is executed and recorded in the file, and then the parents receive a note. If it is not, then the parents may request a hearing. Also, non-custodial parents have the same due process rights to student records. So just because the child is not living with the parent does not give them a reason to not be able to view their child's record. The rights of school personnel. Teachers, counselors, and administration must have a legitimate educational interest for viewing the student records. When they go to view the records, they must have a written form signed and kept in the file. And this should include the files viewed and the date that they are viewing the file. Each person viewing the file must sign the form. So every teacher, counselor, and administrator that is there viewing the file, they must all sign the form and file it in the student's record. If a parent or someone challenges the validity of them viewing the student record, the school must be able to demonstrate the legitimate interest. Okay, FERPA and discipline. In 1994, FERPA amended their rules to emphasize that institutions are not prevented from including records related to disciplinary actions taken against students who, if they cause significant risk or significant harm to themselves or others. They went on to say that institutions may also disclose this information to school officials who have been determined to have a legitimate educational interest, and they may also disclose this information dealing with disciplinary actions to other school officials that have a legitimate educational interest in the behavior of the student. The enforcement of state or federal statutes. Federal and state officials may inspect files without parental consent in order to enforce state laws or to audit or evaluate federal educational programs. So this is the only instance where they do not have to have parental consent. Personally identifiable information may not be associated with any student unless Congress by law authorizes federal officers to obtain this data. Information may be released without consent when applying for student financial aid, and authorized representatives who may access records include the Comptroller General of the United States, the Secretary of State, administrative head of an educational agency, or state and educational authorities. One of the landmark U.S. Supreme Court rulings was on February 19th, 2002, and the U.S. Supreme Court ruled in Owasso ISD versus Falvo that peers grading papers doesn't violate FERPA. Students' papers are not maintained within the meaning of FERPA, and when students correct their peers' paper or call out grades, that is not violating FERPA. If homework or classwork were considered to be part of educational records, there would be a substantial burden placed on teachers. This would require parental consent for even showing a student their own test grade. The first case dealing with FERPA is Ray versus the District Board of Trustees of Santa Fe College. And the question asked in this case is a student protected under FERPA when he or she files a complaint against a teacher in public schools and colleges? In 2012, Ray, who was a mathematics instructor at Santa Fe College, was not rehired based on an email sent from a student to the school. He was hired on a semester-to-semester basis and was ultimately not rehired because of this email. When he asked for a copy of the email, he was sent a redacted copy, and the chair repeatedly refused his request to disclose the author's name based on the grounds of FERPA and the student's identity being protected. In the email, the student complains about Ray's classroom behavior, saying that he made humiliating remarks and unorthodox methodologies of teaching. But Ray alleged he was effectively prevented from defending himself. He also asserted that neither the Florida statute nor FERPA protects disclosure of the name of a student who writes an email. And he alleged further that as a result of the chair's unlawful refusal to give Ray the complete email, he suffered damages. And the courts ultimately sided with Ray and determined that just because a student writes an email, that is not authorized under FERPA to protect them. Briner versus Canyon School District. Briner's son was involved in an altercation in October 2012 at Butler Middle School, and when Briner asked to view the security footage, he was denied access under the laws of FERPA. When he went to court, he represented himself, and the Utah District Court viewed the footage and ruled that it was an educational record because it contained personally identifiable information of other students in the video and was subject to the laws of FERPA. The court said that students in the video were clearly identifiable either by face, body shape, clothing, or otherwise. However, the court would allow Briner to pay $120 for a redacted version and gave a 10-day period for him to request the footage. Briner appealed this decision and argued that teachers, librarians, and custodians had viewed the footage and therefore he should be allowed to view it. The court decided it fell under FERPA, and Briner appealed the decision, claiming it was not an educational record because it was not academic in nature. However, the Court of Appeals upheld the trial court decision, arguing the video falls under FERPA because it contains information directly related to students. So this was an important case because it did not have anything to do with an academic nature. It was just based on relating information to students. And lastly, this last one was School Choice Ohio versus Cincinnati Public School District, and the question was, can a public school rely on FERPA privacy statute to selectively withhold basic demographic information about students? A nonprofit agency, School Choice Ohio, SCO, alleged the Springfield City School District used its records policy to deny the release of information to organizations it opposed. SCO filed a public records request in 2014 for students' names, addresses, and other contact information. FERPA requires districts to keep students' education records confidential, but clearly exempts harmless directory information of the type SCO requested. They did this every year from school districts to conduct outreach programs for families who could be eligible for school choice programs. This information could help local families decide which school to send their children to, and ultimately the court ruled the